everyone. I welcome you to today's class. Now this video is going to expose the learner to what is law, what law is generally all about, the functions of law in a given society, the sources of law, the different sources of law, preferably in Uganda, and then the court system in Uganda. So I welcome you all to this class, and may the good Lord bless you as you listen in and as you watch. So we'll begin with the general definitions of law. Law may mean the rules and principles either enforced by an authority or self-imposed by the members of society to control and regulate people's behavior with a view to securing justice, peaceful living, and social security. Now that definition was by Kuncho in 2005. That the rules and principles, either enforced by an authority or self-imposed by the members of society to control and regulate people's behavior. Basically, what that definition means is that rules are put in place to regulate people's behavior in a given society. So society deems it fit that it should put regulations to control the behavior of people within that given society. Now the second definition is that law is a body of rules designed to regulate human conduct within the country. The definition is by Abbott. That is a body of rules designed to regulate human conduct within the country. Just imagine a nation or society without laws. Laws are the ones which term people's behavior. That is why there are laws on rape. That is why there are laws on defilement. There are laws on murder. For that is the only way you can be able to term a human being. Now there is a business definition. And our business definition is from mercantile law. Mercantile basically comes from merchants, people who used to involve themselves in trade. So this is a business definition. That law, that mercantile law denotes law as a body of laws relating to commercial transactions, business transactions, which include the following: contract law, agency law, and many others. So that is the business definition of law. Now let's talk about the functions of law in a given society. I know there are very many, but I'm going to limit myself to 5. That laws regulate conduct in society. Conduct, human conduct in society. Number 2, laws foster peace and harmony. Harmonious living in society. Peaceful living in society. It is there because there are laws in place. Laws are the ones which limit on the infringement of rights by one individual onto another individual. The reason as to why a neighbor cannot take another person's land is because there is a law on trespass. Mostly. Number 3, laws regulate government powers. Very true. Government uses laws to pass on its powers onto the people because of the laws which are in place. And laws protect individual rights and freedoms. Very true. There are a number of rights that accrue to a human being. The right to life, the right to freedom of speech, all of those. The right to exclusive possession, all of those accrue to individuals and they are mainly protected by the law. And laws promote justice and equity. Laws promote justice and equity. And then I want us to talk about the main types of laws we have in Uganda, or just a classification of laws in Uganda. So we have what we call criminal law and civil law. Very important. And we are saying that criminal law is about creating laws for the protection of society as a whole and providing punishment for those who break those laws. Criminal law sets out types of behavior that are forbidden within society, and if the behavior occurs, then punishment will follow. If you commit a crime, you have offended against the state, and the state has the right to prosecute you. At the end of the case, if the defendant, in bracket the person who is alleged to have broken the law, is found guilty, they will be punished by the state. Now, criminal law, the word criminal comes from commission of an offense, what we call in law a crime. Now, if a person commits a crime, he or she offends a particular law in a given society. And if I'm to limit myself to the Republic of Uganda, the main legislation on commission of crimes is the Penal Code Act, Chapter 120. Take an example. If a person commits the offense of rape, when A rapes B, then he is deemed to have raped a citizen of Uganda. Then a case will definitely be reported to police, and police will carry out investigations about the rape, a number of investigations, and after coming up with detailed facts, the police will charge the culprit or the suspect. They will be charged accordingly with the offense of rape, together with the evidences, and then the file will be sent to the resident public prosecutor, who will assign it to a government lawyer who will look through the file, and if he finds that the evidence on file can be sustained in court, then the file will be sanctioned, assigned to a particular magistrate, and since rape is a capital offense, the person will definitely have to be indicted to the High Court, which High Court is manned by a judge, and then prosecution will begin leading witnesses. Remember that proof of a case in criminal law is beyond reasonable doubt. Beyond reasonable doubt, whereby you have to produce all evidence to prove and show that it is the culprit who committed the act. But what is also important to note in criminal law is that every offense that is committed by a person is committed against government. That is why the cases are usually Uganda versus the suspect. And then when we go to civil law is used to settle disputes between individuals. These disputes may be business disputes arising out of contracts. Maybe A sold land to B, and after sale B found out that actually the land which he bought from A was not for A. So what will he do? He will file what we call a suit in court for refund of his money, and maybe it can come with damages, maybe damages and costs. So that is civil law, meaning that it is individual against individual, company against individual, or individual against company. And we are saying under civil law that at the end of a case, the party at fault has to pay compensation or comply with another suitable remedy, such as an injunction. And briefly, let's go through the differences between criminal law and civil law. Number one is that criminal cases are brought to maintain law and order and to protect society. Civil cases are brought to uphold the rights of individuals and provide redress. Number two, the cases take place in different courts. A criminal case is usually brought by the Crown, brought by a government lawyer on behalf of the government. That's what that means. By the Crown prosecution, the government lawyers on behalf of the government. And the civil case is brought by an individual or company. Yes, the civil case is brought by an individual whose rights have been infringed upon, or an individual who has a cause of action and he wants a remedy from court. Number three, the standard of proof in criminal cases is proved beyond reasonable doubt, while the standard of proof in civil cases is on a balance of probabilities. Number four, the terminology used is different. The person starting the case is given a different name by each system. Criminal cases are usually brought on behalf of the Crown, state, and civil cases are brought by a claimant, i.e., an individual or company or corporation. Now, briefly, let's go through the sources of law in Uganda. For any paralegal, any person who has never gone to law school, or even one who has just come into law school, where do you find laws in Uganda? What are the different sources of law in Uganda? That's what we are going to look at briefly. So we have what we call primary and secondary sources of law. And under primary sources of law, we have cases and statutes. Very important. The core sources of law are statutes and cases. Now, a statute is a written law that arises from an act of parliament. Literally meaning that this is a law which is brought in place by parliament. Now, the main statute of the Republic of Uganda is definitely the Constitution of the Republic of Uganda, 1995, as amended. And we also have other statutes, like the Penal Code Act, the Anti-Corruption Act, and other acts of parliament, written laws. Now, all of those statutes can be sources of law. If you want something on Uganda, you can definitely go to the Constitution of the Republic of Uganda. Now, we also have what we call cases. And cases, these are decided matters on points of law. Decided matters on points of law, or already decided cases from court. And cases may at the same time be referred to as precedents, a precedent. And they may be relied upon by magistrates and judges to come up with a decision in a current case. And cases are usually binding and persuasive in nature. They're usually binding and persuasive in nature. Now, number two, the other source of law in Uganda, we have secondary sources of law. These include law books, they include journals, the encyclopedia, they include dictionaries, They include case books. They include case books and any other written materials on law. So those are secondary sources of law. Number 3, we have what we call applied laws. Applied laws. These are laws which are recognized in a given society. And some of them include common law and doctrines of equity. Doctrines of equity are basically principles of law which cut across all societies. They cut across all societies. For example, every society respects human life. Every society respects human life. And then common law. Common law is the law which was brought by our colonial masters. Let me limit myself to Uganda. Uganda was colonized by the British, the United Kingdom. And during that time of colonization, the laws of the British became common to Ugandans. That is why our law comes from Britain. All the old cases we refer to, like Khalil versus Carbolic Smoke Ball Company, all of those arise from Britain. And Uganda is a common law country. So you find that when we are colonized, we ended up behaving like the British. That is why we dress like them, we eat like them, we speak English like them, our dress code is like theirs, our code system is like theirs, even our education system is like theirs. Basically, we're indoctrinized. We're indoctrinized, and even their laws are synonymous with ours. So that is how common law can become a source of law in Uganda. And then number 4, custom is also a source of law in Uganda, based on trade usages and practices. There are a number of practices which have become law in Uganda. For example, if we look at the Baganda tribe, payment of dowry, you cannot take a lady from Buganda without payment of dowry. When you look at the issues, for one to become a man, he has to be circumcised. And society knows it that if you're a Mogishu, you have to be circumcised. And lastly, under sources of law in Uganda, we have the internet. That animal called the internet is a source of law. You can just go to Google and then you'll be able to get all that you want in regard to what you're looking for. And lastly, in today's class, we are going to look at the structure of the court system in Uganda. The structure of the court system in Uganda. So the highest appellate court of the land, that is in Uganda, is the Supreme Court. Is the Supreme Court. And the Supreme Court is headed by the Chief Justice of Uganda, who happens to be His Lordship, Justice Owinyi Dolo, together with other justices of the Supreme Court. Now, the Supreme Court is the highest appellate court in Uganda and entertains appeals from the Court of Appeal. It also handles presidential petitions. It also handles presidential petitions. Number 2 is the Court of Appeal. The Court of Appeal handles matters from the High Court and constitutional petitions. It also deals with interpretations of constitutional articles in the Republic of Uganda. And it is headed by the Deputy Chief Justice. is headed by the Deputy Chief Justice together with other justices of the Court of Appeal. And then we have the High Court as the first appellate court of the land. Now the High Court has jurisdiction over all matters in Uganda except constitutional petitions and presidential petitions. Because like we said, constitutional petitions are handled by Court of Appeal and presidential petitions are handled by the Supreme Court. But all other matters can be handled by High Court. High Court has a discretion. Now High Court is actually headed by Justice Zeide. High Court is also in divisions. There are a number of divisions which handle different matters. And every one of those divisions is headed by a judge. Some of these divisions include the commercial division, the land division, the criminal division, the family division, the anti-corruption division, the war crimes division, the civil and executions division. For example, the anti-corruption court is headed by Justice Lawrence Gidudu. Now we also have the magistrate courts. We have the magistrate courts, and these include the magistrate grade 1, grade 2. There also used to be a grade 3s, though they are no longer in existence. The magistrate courts are headed by a chief magistrate. They're headed by a chief magistrate. And we also have local council courts, like LC1, LC2, and LC3. And then quasi-judicial bodies. We have quasi-judicial bodies. These are bodies which arise out of acts of parliament, like the Tax Appeals Tribunal, the Leadership Court Tribunal, Human Rights Tribunal, and other courts. Thank you for watching. May the good Lord bless you.